That's the one.
So now, you now just tell us what.
The only thing is, bro, when I spoke to doctors again at Bombay, and also here, this time allotted, they're saying primary board within 24 hours and review board within 48 hours. Because what they're saying is every day in the ventilator is an agony for the patient, and the primary board doesn't require 48 hours to come to a decision that it's terminally ill, etc. So one request is on the left-hand column, Lordship makes it 48 for 24 hours. And they say review board. In fact, they are saying review board. Many people feel there's no need for a review board, but since they're having a review board, let it be there in original judgment. I would say 24 hours, 24 hours. That's one point. And secondly, my lord, this secondary board. Sorry, Lordship has got secondary board in the middle. My lord.
Correct.
This one or this one?
No, this one. Because here, everything except there are 2 points of differences. One is this 48 hours, 48 hours. They're requesting it 24, 24 because time is of the essence. And secondary board, doctor nominated by CMO. Our suggestion is not what we had suggested, and in fact, the discussions took place, they initially agreed. Instead of having every time a person nominating, let there be a review board wherever available, where this review board is always there. And that they can take a quick decision because the primary board has taken it, they've got a report, they give reasons that he's got this 4th stage cancer or 4th stage this point. The time is very limited. So the review board, because again, if you nominate the review board, that doctor must be free, he must come, all those problems will arise. So
No, this when you talk about
secondary board.
yes, you said 2 subject experts not part of the primary board.
That's agreed. That's fine.
Now these.
The only difficulty is doctor nominated by CMO. So the Lordship can think of some modification.
So nominated by no. You have said doctor nominated by the CMO plus 2 subject experts. Are the subject experts also to be nominated by the CMO?
No.
This is what we want to know.
No.
Second thing is whether the 2 subject experts must be from a different hospital.
No, not necessary.
I mean,
we did discuss the threadbare, not necessary.
When you say not necessary, we are only putting to you that there may be cases where you may not get. The first board will have a subject expert. Then if you will need to have another 2 subject experts.
Yes, if they're not available, they'll go to the nearby hospital.
That's what is.
Wherever available. No, suppose it's like Safdarjung Hospital or say in Madras Government General Hospital, which has got a 10-story building with 200 doctors, then there's no problem. In fact, I was suggesting to them that because it's a trial basis, because like any product you have a trial marketing, whether to start it in major hospitals, but they didn't want to complicate it. So I'm also not getting into it. So, one is 24 hours, 24 hours. Now, your Lordship may suggest what instead of nominated by CM, if your Lordship has got some suggestion to make it workable.
48 hours mean it starts ticking from when?
So, from the time the patient is admitted, and or suppose he's there for 8 days. 8 days he goes into a coma.
Once constituted.
If you tell us,
Once
this
constituted.
48 hours will start from when? Does it start, clock start ticking?
Constituted. Once constituted, they have to, once it is constituted.
My doctor colleague here says that 24 hours from the time they know that the end is inevitable.
It is 48 hours, isn't it?
No, we want to suggest 24 hours because uniformly they have made it 24. The government is suggesting 48. We are saying at least primary board because they are the treating doctors. They don't require 48 hours to make up their mind. If you see treating
It's not so difficult. No doctor will say that end is inevitable at this point of time.
Yes.
I mean, 48 hours is, I think, very reasonable. So that is not.
Or Lordship can say not more than 48 hours.
They can do it at the earliest.
Correct.
But not more than 48
Not
hours.
more than 48 hours.
Yes. And so
And that too, this cannot be, supposing you do something beyond that, then will a contempt lie? We have to be careful.
no.
Somebody will come and say that 48 hours is
We'll see you in charity. But it has taken
Don't
hours
say
to.
that we will see. We have to, Datar, you have to be careful. The direction of the Supreme Court, it will be binding.
Yes, Lordship may say not more than 48 hours. Within 48 hours. Within 48 hours.
So what is the new?
Within 48 hours is enough.
Within 40. primary board.
Body board.
No, 48 hours to give the opinion. The primary board is the
No,
treating
how,
physician.
how does one file a petition or how would that happen?
No, there are two cases. There is
They
the
have to obtain the opinion of the primary board.
Yes.
No,
Because they are reviewing on that.
initially, the attending doctor to advise that
No, there are two cases. Cases where advance directive exists, cases where advance directive doesn't exist. That is para 198 of the judgment and para 199. So
but
199 if advance directive doesn't exist.
even if
No.
advance directive exists,
Let's go to that category first.
uh,
So just for the easiest.
then also it's difficult. Somebody must say that it's a point of no return.
Yes, that's a treating physician.
That has to be treating
The
physician.
treating physician.
Then he will refer it to the primary board.
But he is not, his opinion doesn't count. He has to bring in two
No,
more experts who
He has to
concur with him.
refer it to the primary board.
He is part of the primary board.
Okay, so he
Part
has
of the primary board. So it's treating physician plus two more. So within 48 hours, we said 24 hours, Lordship is saying within 48 hours can be even, because suppose
This is applicable only in the case where there is an advance directive.
No, that is, I'm just saying two compartments. One is advance directive where the person's wishes should be respected.
Correct,
And what the Supreme Court says is that should be respected.
correct,
And the primary board decision is only subject to a review board.
correct.
Now, suppose there is no advance directive.
Then we are not here to.
No, that's para 199. That's a very important part of the judgment.
Let's therefore see which are these provisions, how do you superimpose them?
Yes, here.
Which one?
I'm just saying, no,
Here
no.
we don't have it.
No, I just go step by step.
That's right.
If the advance directive is there, in the format suggested by the Supreme Court, which
This is a
is
joint
made,
submission.
signed by two witnesses, etc. Lord, can I do one thing, Lord? Better is this is the agreed, like a minute which we discussed and agreed upon.
This one.
No, this narrative.
We'll have to place it along with the directives already exist.
Lord, what happens is, Lord,
Which
this
part
directive
is
and this chart matches except this 48 hours and secondary board. Everything matches. This is a very simple format. Instead of reading 8 pages, this is,
And also doing away with the judicial magistrate or whatever.
that's completely done away. The judicial, then we might as well close the case. It's not possible. Then there's no point in having that one. Only intimation to the judges. The entire para 199 of the judgment. at
No,
page-
but Natarajan, this judgment was only dealing with cases where there is a
Advance
advance directive.
Advance
Para
directive.
I
199.
think Mr. Datar
Yes.
does take into account a situation where there is no advance directive.
Yes.
And paragraph 199
199
deals with that.
No, leads only with that. Then
That's
you have to, then you require the consent of the kith and kin. Then the doctor can counsel them.
No advance.
Just read para 199 so that
Yes, yes.
there is a clarity.
At page
Mr. Natarajan,
133.
you are also.
Yes, yes. In case there is no advance directive, that's what it says, second sentence.
Advance
Para 199.
right.
Where there is no advance directive, the procedural safeguards are to be same as applied in case where advance directive.
Tamil and otherwise non. So it's 199.12.
Yes.
It is the same, huh?
Yes. Broadly the same.
Is there any difference?
No, only the consent of family is required. The very idea around the rate, you don't need the consent of family. The patient wishes is respected.
Yeah, this is the family.
That is with
Advance
advance.
directive, yes.
Without that, it's going on now also, with consent of the family.
No, now what happens is with this Supreme Court judgment comes, then there is no allegation, the doctors are protected. They consent. Now, without advance directive, they get the consent of the family. The family can choose, no, I want the person to continue indefinitely. If they're willing to pay for it, yes.
What will happen if a family consists of the wife and say two children?
Hmm.
And what is the definition of family? Would you take in brothers?
Immediate family, we're saying, immediate family.
What do you mean by immediate family?
Available.
We are telling you what you'll run into problems. We are telling
No,
you.
not, what the
Supposing you have, say, the wife says,
But Lordship, imagine a practical situation where X is, suppose a senior lawyer finally goes to the hospital. Who will be the family, his son, wife, etc. Now we can't say his brother also is there.
supposing we are asking you,
Yes.
supposing say the 2:1. Supposing if a close family, say wife and two children, let's take it.
Yeah, well, I discussed that. Then what they say is, then the people will say that the person, the family which wants to continue will bear the cost of the treatment. They will bear the cost. Because when the doctor has said that there is no point continuing the treatment,
Yes.
They define what is family.
Okay.
In page 7, I just read it.
Anyway, we will not get into that.
The spouse or de facto spouse or partner with whom the patient has a relationship as a marriage or a friend.
Why should incur a honestness and create more problems? we thought that it should be Nataraj's lookout to tell us, but he
No, but AIMS has got it, brother. Spouse, adults, sons, where available. Then if adult sons, children not available.
okay. Now we have got it. So both the advance directive and no advance, both
Yes.
it is applicable. Now let us see which are the provisions which are to be modified.
Yes. Now, if your lordship wants to
So
speak.
this is a clarification petition. We have to bear in mind. We can't take it
Correct.
unless there is complete consent.
Yes.
Yeah,
No,
no,
but I'll do one thing. This is the charge they gave me finally.
That's right.
This also matches. Please tell me this matches. Only where there is a point of difference is it
So what
48 hours or 24 hours?
We intend to dictate the order right now.
Yes,
To what?
yes.
So that it can be done, any correction.
Yes,
modification
yes,
can be done.
yes. Now, but only thing your lordship has to say,
So what we intend to say, the format is, we'll tell you what you meant. Just say what the clarification, and then the preliminary
yes,
hearing.
but your lordship,
So today you have come to us, and we'll set out the procedure which has been laid down in this clause, so that anybody who reads the order, we will know.
but we have suggested in the narrative form. Lordship may follow this, if your lordship so pleases. This chart, which is called, it's got into 7 pages.
What we have to do. See, that is already directions. One set of directions.
Exactly.
So to what extent those directions, which are those directions which will stand modified?
That is also done. 3 things are done. This is the modified directives. This is the chart for your lordship's easy reference. And this is the final chart which they gave me just now before lunch.
So let us see that, modified chart.
Yes.
Because
What they did.
if we give the original chart, original directions, and then we say that it is clarified that, then that will do the
It'll be
trick.
easier. It'll substitute
It will
that.
be both, so
Your
that
lordship is
somebody
right.
who reads it will know what is, this
I appreciate. Lordship is right.
is what the format we intend to do.
Yeah. This is the latest chart with black and red ink.
Where is it? This one.
Yes. But is it the page 1 ends with 198.3.5? The first page, does it end?
That's right,
That's the chart.
3.1. With a red bit.
Yes.
That is, and attested before a notary or,
Your lordship suggested, and your lordship said put or gazetted officer.
This one, page 7 and para 7. Page 7, para 7 of this note.
Don't come to that. Don't see that right.
This need not read.
Not only now, today, black and red.
so, you have said in 198.3.2 that the witnesses and the notary shall record their satisfaction.
Yes.
Now, in the earlier clause, you have permitted and attested before a notary or gazetted officer.
All right. Lordship is right, because it'll be in synchronization with one.
Yes, because supposing it's before a gazetted officer, he should also certify
Right.
witnesses and the notary or gazetted officer, correct?
Yes.
Shall record their satisfaction that the document has been executed voluntarily and without any coercion or inducement and with full understanding of all the relevant information. Then what is to be done with this, what do you call this, advance directive? What we had in mind, we had a discussion. One more additional safeguard we wanted to incorporate, which is that once this is done, they should get back to him that he confirms in writing. It is just an additional safeguard. See that you have done this, and he writes back. So that will be kept along with the original declaration. This is to avoid any kind of fraud which you can, and it's somebody who is doing it in
Give
writing.
it to your lordship, because suppose I go to the gazetted officer, I sign it before him. Now-
Or he comes before you.
Whatever it is, very unlikely. He may want me to come before him or for a notary. Notary, I'll have to go to the court campus and get the notary to do it. Now, I sign it before him. Signed before the notary, public witnesses are there. Now, in my humble submission, it may not be necessary for them to ask me, are you really written? And I write back to it. I'm signing it before them.
We know that, but we are just saying in our country.
You can put it before lordship. Because what I spoke to some doctors again in Pune and Bombay. They said that
What
all over the world,
Nataraj?
Some safeguards, whatever this one.
But that'll,
That will-
then where is,
No, because in a will, we don't say, did you sign the will? Yes, I signed the will. I sign it.
no, what
witness
is
that-
done with this? What is to be done with this?
Which one? No, that goes to the National Record Mission. That's coming later. The National Digital Health, yeah.
Probably in the countersign.
Lord, I'm told that later in the day, this document is handed to the family members. One copy to the Gazette officer and one electronic record is kept with the national,
Part of the digital health record.
part of the digital health record. So even if I have an accident somewhere in Bangalore, it can be accessed anywhere.
So these notaries are governed by the Notaries Act.
Yes.
Is this a document which is actually contemplated under the Notaries Act? Because
Yes.
they got a stamp, etc.
No, there's a notary stamp. He puts
That's
a,
right.
it's a
So
stamp.
is this a
It's
document?
actually rubber stamp. He doesn't put any court fees. He just puts a rubber stamp.
That's right. That's right.
He's authorized. He's been authorized by the respective High Court to be a notary public.
That's right. Huh?
Authorized to administer.
So do you want to? Be done this.
In page 2. The Lordship's answer is in page 2.
So we are deleting, we have to also now see that JFCM goes out,
Yes.
shall forward one copy to the
JFMC goes.
That is also going to be deleted.
Yes,
Nataraj, you're agreeing
Yes,
with that?
yes.
All right. Then 193.5 shall inform the immediate family members of the executor, if not so and so. Executor shall inform and over a copy of the advance directive to the person or person named in paragraph 192.5.
This was your Lordship's suggestion.
Hand over a copy of advance directive. Within what time? Supposing he gives it after the, you have fixed the time.
Let it be, Lord. You can't, we go, because expeditiously.
Put it within a month. So that, it will become
Because
certain.
Lord, I spoke to some doctors who are dealing with some similar cases. They said throughout the, no, I'm not talking Western world, they said they take it like a will. It's just a declaration that it happened, that's all. There's no great formality I must put into some US medical record and all that. The document is just available, that's all.
98.2.5 is who? 198.2.5 is who?
It's in the 198.2.5
Ah.
is immediate family, one second.
Should specify the guardian or the close.
Specify the guardian or close relative who in the event in becoming capable.
So it will go to him.
And Lordship said put guardians. Lordship said put in bracket S. Guardians,
That's right.
guardians or close relatives.
That you have not put in this note.
No, only what is to be modified. Lordship wanted only the thing which are modified.
That's right, but it should be there, no?
The 190 is not being changed at all.
198.2.5 we have suggested
Yes,
in place of guardian or
Okay.
relative, it should be S.
yes.
Because in case that man dies, or he becomes incapable.
Then 198.2.5 should become plural.
That's what we are saying.
Yeah, Lordship is right.
198.2.5. We are writing it here, eh?
Yes.
Sure. 0.2.5 will become parent. I mean, guardian will become
Guardians or close relatives.
or it will become relatives. That's right. So that is okay. Then 198.3.6.
Yeah. Your Lordship asked who? And also choose because of privacy issues. Lordship said that leave it to his discretion.
This 198.3.6 original will remain. You want this red portion to be added.
Yeah, the original portion will be there.
Will be there.
Yes.
Ah.
So only the red part will be added and aforesaid will come. Oh, aforesaid also is. Aforesaid also is there.
Do you want to put any time limit within which they should do it? Not necessary. Okay. a copy shall be handed over to the ground. No, you're adding what actually? Uh, this red portion is to be added, that's all. No? Why
That's all.
complicate it?
That's
But
all.
you have said something shall be handed over to the after that.
That's the same paragraph.
Repetition of.
There is a repetition. Na? What we thought was
Yes.
this red portion can come at the bottom of the original clause.
All right,
Correct.
all right.
Then we don't have to add that. You follow. So we are just cutting that portion.
And
on the
shifting
right
it to
hand-
the bottom.
Huh?
And shifting it to
And
the end.
that will come to the bottom of on the left hand side.
Yeah, I agree. No.
That then JFCM that is deleted. Natraj, no
Yes.
problem.
Yes,
In the event, then comes 198.4.1 becomes terminally ill. In the event or is in the end stage of a chronic disease
But this comes from the ministry, my lord.
and is undergoing prolonged medical treatment with no hope of recovery and does not have any decision making capacity. Four point one. Have a day's reflection and dictate it tomorrow. I mean, that you dictate it tomorrow.
Yes, please. And I would request if your lordship still feels something else, we have to mull over. So also because it will be now, what your lordship pass will be now permanent.
You see,
Till they pass a legislation.
One should go through it.
But can your lordship go through it just now quickly?
That's right. So that, whatever.
As if your lordship has got any particular doubt, then.
That's right.
No, because I'm not having doubt, I'm taking away.
So now this, what do you say, 198.4.1, this is a radical change.
Sorry.
The radical change is or in the end stage,
No, that is the request of the ministry.
whether it's the ministry or whether it's you.
No, that's also just
Completely.
Chandrachud's
We are
judgment.
tinkering with the judgment.
No, Chandrachud's concurring judgment also says that. That's also Article 141.
No, that's not. So this is completely changing the,
Or delete it, my lord. Delete it. Anyway, it's terminally ill.
in the event, yeah, that's what we thought. And is a prolonged
I have
underlying.
no problem about it. It is a ministry suggestion, what you want, because terminally ill is terminally ill. But terminal ill is wide enough to include this. Technically speaking, it's a genus.
It's a gene.
Terminal ill can be all the species of that.
Absolutely. Terminal ill person
See, once
would also be in the end stage of
By
chronic
definition.
disease.
give it.
Why do you want to, Natraj? Why are you insisting on that?
No, the thought is there should be some kind of check on the authenticity
Why
and
we are saying
situation
the
also.
original.
But they doctors also.
It's a clarification.
Yeah.
And we should not be, doing it on what those judges taught and, conducted.
Very well, I'll-
Because if the first part takes care of it, because it says in the event of the becoming terminally ill
ill.
I think we'll delete it.
and is undergoing prolonged medical.
No, no, Rajshri straight away cut it out. my lord.
Yeah. This we are not ignorant.
There's a saying, Mr. Datar,
Yes.
when thinking men think there's nothing to think, it becomes time to think.
You are-
Very true. Very profound also.
And then you have added another red there and does not have decision-making capacity.
This is very necessary, my lord. This is very necessary because I may have an advanced directive. If I have a decision-making capacity, I can change my mind also. So let that be there.
For a change, you are turning pro-life.
For a change. No, my lord, I am not pro-death, my lord.
And cure of the ailment, one cure of the ailment. Then you have brought in treatment when made aware of the ascertained genuineness and authenticity of evidence to be existing digital records of being or from the custodian of the document mentioned in, that's okay. That addition is, I think, welcome. So we'll get this information from either this or that. That's okay. That does not have decision-making capacity, what you said, I have no problem with it.
But they're very serious about it. They want it.
So he may say, I don't want it. He said, don't do it, something like that. Or he is saying, do it fast. You don't know. All right, so that is, I think, subject to what you may think about it, we can. Then comes 198.4.2 instruction, the document must be given due weight by the doctors.
Again, that has to go, my lord. 198.4.2, again, that chronic illness can be cut off.
Or in the end stages,
That's been cut off.
not at all necessary.
Not-
Then comes
198.4,
0.3.
that's very minor.
If the physician treating will is satisfied, the instruction given in the document need to be acted upon. You shall inform the person's name. Yes,
That's it's automatic, my lord, nothing to.
that's nothing much in it.
No, your lordship has to really decide on 198.4. There we require your lordship's inputs. The bench has to decide on that.
So the person so and so has a replied the steps for change. Then 198.4.4.
Yes, that's what I'm saying. There your lordship has to take it.
Hospital where the executor has been admitted to medical treatment shall then constitute a primary medical board. I just want to highlight one, supposing somebody was executed an advance directive, gets admitted in a hospital with just the rudimentary medical facilities. What will happen then?
Nothing. There will be no primary board.
There will be no primary board. Then what will happen then?
Nothing. He'll continue treatment or he will die, whatever happens. Nothing can be done. Lordship is right. Suppose a person gets an accident in the highway somewhere, he is taken to the nearest health center. What to do?
What to do? Nothing can be done. Okay. Admitted for medical treatment shall constitute a primary medical board consisting of the treating physician and at least two experts with. Now, this is a major thing. You're going to cut down, take out the 20 years experience safeguard, substitute it with subject expert.
Or at least 5. Because the answer was the person gets subject expert when he's 33, 34. He has to study, keep on studying till 24, 25, 26. After MBBS, then they do residency, then they do MD, then MS and so on and so forth.
And you're making it 5 years.
5 years experience.
What is the view of the government?
They agreed to this. These are all agreed suggestions, my lord.
That's right. We wanted to confirm to that.